our guest this morning, Malachy Ugumadu. In my mind, I always want to add 3 initials after that name every time I say it. But it is well for now. Good morning, Malachy, constitutional lawyer. Thank you, as always, for coming. And I seize the opportunity to say a Happy New Year. This is the first time we're seeing.
Happy New Year to you, sir.
Indeed.
Happy New Year to the viewers.
Indeed.
Except to observe almost immediately that you're looking a new look. There's a new look on your face, and I'm sure the viewers have taken note of that.
They've taken due note, as you lawyers say, from time to time. But thank you very much for coming on. I was just making the point, perhaps needless point, that this is a very, very serious case here. We're talking here about being charged with a refusal to finance, a refusal to prosecute financiers of terrorism when the files had been laid on his desk in the first instance. And all the other charges, apart from the one that concerns the property that somebody has spoken about, all the other charges concern firearms, stockpiling. In fact, I think they even use the word warehousing. Maybe we'll come to talk about that, because when I hear warehousing, I think of a very big facility where things are stockpiled, but maybe there's a legal definition of warehousing. But let's first of all take it from the very seriousness of these charges, and these charges being laid at the feet of a former chief legal officer of the country.
Well, again, thank you for having me.
And
good morning to your vast viewers around the world. I'm glad that this topic is in the front burner, at least for you at TVC. I'm also very cautious this morning, realizing that those charges are before a court at the moment. In other words, the matter is subjudice. However, I will deal with the general story and the principles around it as it affects the Nigerian public and our polity. Because this is also no ordinary person. He was, yes, the former chief law officer. That's your word, and that's very correct if you are referencing section 150 of the Constitution. It describes him, in fact, any Attorney General, as the chief legal officer, law officer of the Federation. There are not many such public servants that are so designated in the Constitution, not in status, law books, but in the Constitution. So to that extent, it's of public interest. Now, what are the issues? You recall?
Well, sir, I beg your pardon for interrupting you, because as we were speaking, Tony also came in. But we're going to hold the calls now that Barrister Ugumadu is in the house. But in the meantime, since we did invite calls to start off with, good morning, Tony, in the UK. Tony, can you hear us in the UK?
Yes, I can hear you now.
Okay.
I can hear you.
Okay.
Hello.
Thank you very much for calling in. Please go ahead. You're the last of the calls that came in preliminarily.
My concern ever is that, hello, can you hear me?
Very well, very well.
Yes, my concern ever is that Nigeria, since they started convicting and getting people who were just against corruption and all that, I have never, or who can ever tell me the person who has, somebody whom they have, convicted for any offense like this or corruption, they are fighting against it. Anybody they accuse, 2 minutes, 3 minutes, the case will be over. Somebody like Yaya Bello, when they accused him, they were, thinking, oh, this, that. Before 2 minutes, everything was over. Who can ever tell me the person they have convicted Everybody that eats Nigerian money, 2 minutes, the person will be free.
All right, Tony, thank you very much for calling in. And I'm sure, you know, my guest, Barrister Ugumadu, has noted that point, and somewhere along the line, he will comment on that aspect. Please continue.
Thank you. So
we're going to hold the calls so that, you know, we can hear our guest.
So I had made the point that this is one of the high-profile cases that the Nigerian law enforcement agencies have been able to institute. In the first instance, relating and concerning the same defendant, it was financial crimes, amounting to about 8.7 billion naira. This has to do with terrorism charges. All of them are allegations that has graduated to charges now because they've been filed before a competent court of law.
Okay.
Has it been proved? No. That will happen after due processes, proper prosecution, where he also will have the opportunity to defend himself. They will lead, prosecution will lead their witness in chief. He will have the opportunity to cross-examine them. He will open his defense. They will be cross-examined, and all the fireworks, including the final written addresses, before the court will have the opportunity to pass judgment. Thereafter, sentences will occur if he's found guilty. That's the standard. And he should know, because for 8 years, I imagine, he was the chief law officer of the country. Now, I think we should give credence to both the EFCC in the first instance and now the DSS in the second instance for at least coming to the point where they feel sufficiently convinced that there is a prima facie case against this man.
Okay.
Because no country proceeds with this caliber of defendant without, first of all, getting convinced as a prosecution team that there is a case that exists out there. Because you make a fool of yourself and then turn the whole thing into a mockery if you are not, at least within the thresholds of your operation, convinced that this is a case worth pursuing. And I think that in many respects, that can resonate the confidence of the people of the country who have, to a large extent, lost confidence in the whole process. It also sends a signal that we have come to the stage where even high-profile state actors, you know, people who were in government, people who, you know, were in the corridors of power, could be arraigned before a court of law. I imagine that what the Nigerian people want to see is proper conviction and let them serve their prison terms, as the case may be. Now, but it will follow the due processes just so that we don't also rush to conclusion when somebody may otherwise be innocent. It were better that 9 guilty people escape justice than one innocent person is implicated wrongly. That is the philosophy of the law. But I think that this is a case that will galvanize the interest and attention of the Nigerian people, because it is not too long a time, just a few years ago, less than a decade or thereabout, this man superintended the affairs of the Ministry of Justice like a colossus. And some of us who are lawyers were not satisfied. In fact, the way he conducted himself cast aspersion at the quality of what we do as legal practitioners. And I had so many occasions to mention it. Never mind that he's holding the short end of the stick now. But I'm sure that we don't all suffer that institutional memory that makes us forget many of the cases that were brought before the ministry, and many that ought to attract his attention, many bordering on the security of this country, and we didn't see anything. Now, if you look at Section 174 of the Constitution, it talks first about initiating. You know, people reference, oh, he can enter a nolle prosequi. No, that's not the first thing. The first thing Section 174 is concerned about is to institute and take over. In fact, as the leader, or as one who was in the leadership of the Committee for Defense of Human Rights, I was the General Secretary then, we had cause to query his predecessor, the Attorney General of this country. And the cardinal point of our contention is that we were able to assemble so many cases that were withdrawn from court by way of nolle prosequi, many of which were known cases that needed to be dealt with in a way that puts an end to the madness that had befallen the country then. And of course, you know that that particular Attorney General was deranked on account of that. We did it at the CDHR.
That is Committee for Defense
of
Human Rights.
Yes, on record. So when you now hear that part of the charge is his refusal to prosecute terrorism cases, terrorism financing, many of which were documented and brought to his table, my mind goes back to the same Section 174 that does not grant the Attorney General the power of nolle prosequi. Nolle prosequi is to withdraw from court an existing case. Okay. It's not a case of refusing to. Okay. In short, the case must have been existing.
So there's a difference in that regard.
There's a difference.
Because I was going to ask you about